Hi, I'm Daniel Findling with Findling Law and thedivorceguy.com. With school just around the corner, I thought it'd be a great time to discuss a common question that comes up with parents who have recently gone through a divorce or are operating under a custody order. What if the parents cannot agree on a decision regarding which school the child goes to? How do you resolve that situation? Well, under most cases, parents are awarded joint legal custody. Joint legal custody means that regardless of parenting time, both parents have an equal say regarding major decisions, such as choice of school. Other legal custody decisions include things like medical records and so forth. Well, if the parents do not agree, there is a best interest hearing. A court will decide. And the seminal case of Michigan law is called Perrin versus Perrin, which addresses the burden of proof and so forth. Now, prior to putting this blog on, prior to videotaping, I'd written a brief on this very topic in preparation of a trial. And I thought it might be interesting to share with you the major points of the brief and try to bring it into language that you can understand, or maybe that a layperson could understand. Certainly, if you're a lawyer watching this, you'd understand it, and I'll cite some important cases for you as well. Now, as I mentioned earlier, the seminal case is called Perrin versus Perrin. That just happens to be the Supreme Court case, the family Perrin, addressing this issue. In another case that comes up often in choice of school cases, it's called Lombardo versus Lombardo, which is the type of hearing this is. It's an evidentiary hearing in which we discuss these issues. Now, what does Michigan law provide regarding choice of school? Well, if the parents cannot agree, there is a Lombardo hearing. There's a hearing has to take place regarding what's in the best interest of the children. And what the Perrin case tells us is that in examining what's in the best interest of the children, you should narrowly tailor the 12 best interest factors into the decision of school choice. Now, the best interest factors are really broad. They include things like the love, affection, existing emotional ties between the parent and the child. Obviously, both parents in most cases love their child, but what does that have to do with school? It doesn't have a lot to do with school, but we try to tailor these interest factors because that's what the court gave us to choice of school cases. For example, the other best interest factors, and I'll read them from my brief: the capacity and disposition of the parties involved to give the child love, affection, and guidance, and to continue the education and raising of the children, and including his or her religion or creed, if any. Now we have a little bit of insight to encourage education, the capacity and the disposition of the parties to encourage that. Well, certainly that would be relevant to some capacity to a choice of school case. The length of time the child has lived in a stable and satisfactory environment, a best interest factor. Well, if one parent just decided to move to another jurisdiction where the child doesn't have a lot of friends, that may be a very important factor. The moral fitness of the parties, we presume most parties are fit, and it is not really relevant to most choice of school cases. However, if one parent has a drug or alcohol problem, it may be. The mental and physical health of the parties, the same type of analysis. If somebody is bedridden and not capable of taking the child to school or not capable of doing homework, maybe it's relevant to a choice of school case. The home, school, and community record of the child. Well, we can narrowly tailor this best interest factor to a choice of school case. That is, how is the child doing in school now? If the child's failing every grade and has failed every grade, maybe a change is due. Maybe another district or another school offers additional opportunities or guidance for this child who may be struggling. The reasonable preference of the child can play a role if the child is of suitable age to express a preference and the court wants to listen to it. That certainly can play a role in a choice of school case. The willingness and ability of the parties to facilitate a close and encourage a good parent-child relationship with the other parent. If the parents get along, well, maybe it's not relevant in many choice of school cases because clearly the parents aren't getting along as it relates to this decision. All right, so now that we know what rule applies, the same best interest factors that we look at when we examine custody is going to play a role in examining school choice cases, except we're going to narrowly tailor those best interest factors to the issue at hand, to choice of school. So we look at things like MEP scores, standardized testing, the child's attendance, friends, and so forth. what school is really going to be a better fit, the availability of the parents to take the child to and from school, and so forth. Now, there's another variable that really plays a role in many choice of school cases, and that is, well, what if changing schools will really change parenting time? Maybe in your case, or in a case, the parents had equal parenting time, and one parent decided to move away 60 miles, and he or she can't take the child to and from school as a result of that move. Well, that certainly is relevant. And in fact, if the court would, let's say, move the child to one school or the other and make that award, maybe we have to change parenting time in order to do that. Well, this is where the law really takes a turn, and probably for the good. If the change in parenting time to accommodate the choice of school decision rises to the level where there's a change in custody, that is, one parent will now end up with more or less parenting time than the other. If it changes to put it in legal terms, the established custodial environment, which from a legal standpoint means with which parent does the child look to for the regular necessities of life over an appreciable period of time. If changing parenting time and choosing a specific school will result in changing the established custodial environment, a court is not permitted to do so unless there is clear and convincing evidence, a very high burden, that it's in the best interest of the child to do so. If the parenting time schedule and the choice of school decision is not really going to be modified by the decision, then the burden of proof is simply preponderance of the evidence. Now, we all hope that parents can get along and reach a consensus as to what's best for your children, or child as the case may be, as it relates to choice of school. But if the parents cannot, preparation is key in making certain that everything is in place to ensure that your request, whatever it is that you desire, is achieved. Now, there's one more afterthought. If the change of school includes, and sometimes it does, moving out of state or moving more than 100 miles, we may have to look at change of domicile as well. And I invite you to, call me and ask questions about change of domicile or choice of school. Reach out to us on our website. We have a tremendous amount of articles on thedivorceguy.com. I'm Daniel Findling with Findling Law. My blog and website that we're very proud of is thedivorceguy.com. I want to thank you for watching this video. If you have questions, feel free to call me toll free at 877-YOUR-FIRM, YOURFIRM, 248-399-3300, is our telephone number directly in the office, our local number. And you can also visit us on thedivorceguy.com. Thank you so much for taking the time to watch this video, placing trust and confidence in what we have to offer you. Let it be our privilege to help you. Thanks so much for watching.